Thanks very much for coming and wet, rainy night. And this talk, this paper really is, in some respects, an outline of an agenda that, in a sense, I'm trying out on you, but actually I'm quite happy about how it's fallen into place. And it'll hopefully make sense as it unfolds. The context for it is sort of a twofold one. A couple of years ago, Professor Yoshiwada, who's one of Japan's most distinguished law and society scholars at Waseda Law School in Tokyo, and also actually part of this MCRI, but I've known for a long time. There was a change of government in Japan, as probably most of you know, or some of you know, and a more liberal government was elected, and the Professor Wada works quite closely with this new government. To a certain extent, it was a sort of an opportunity of a lifetime for lots of people who had supported a non-conservative government in Japan. And the conservative government in Japan in the late 1990s had introduced new legislation around malpractice. And in effect, what they did was they criminalized malpractice to a heavy degree, to the extent that about 100 lawyers a year were being charged with criminal malpractice in Japan. And not surprisingly, the various Japanese medical associations gathered behind the new government to pressure them to really significantly rethink their malpractice law in a broader context of thinking about medical error and medical mistakes. And what Professor Wada did was the Minister of Health brought a number of people from a comparative group of countries. They brought somebody from Taiwan, Korea. They brought me, and they brought three distinguished legal academics from the United States, all basically with a mandate to do two things. One is to talk about how medical mistakes and malpractice were handled in the respective countries, and to sort of draw lessons from that to instruct policy development in Japan. And what made it actually a pretty unique experience was that they also asked us each to bring 2 senior PhD students with us to sort of participate in this kind of really a roundtable, really intensive thought experience. And so, I brought 2 of our advanced PhD students from Osgood who were working on healthcare, and somebody. Eric Feldman from Penn Law brought a couple of people. Somebody from the University of Washington brought some people. So there was sort of this group of about 20, 25 people, and a group of Japanese policy people, and as well as academics. And really, the idea was what can be learned from the comparatively thinking through that exercise. And from the start, I actually thought it was kind of a little bit half-baked, even though it was a terrific experience at one sense, and actually for the graduate student, it was a wonderful experience. But there was a sense in which it was an odd phenomenon, because intuitively, as a sociolegal scholar, I knew that looking at malpractice didn't really get at how in Canadian society these problems are really handled. And so in a sense, it was a bit of a red herring to focus there. And the same thing was quite evident when I heard both Taiwan and Korea, of course, have civil law systems, and they actually have interesting innovations in their malpractice laws and so on. But again, you kind of got the same sense there. The Americans, of course, have documented this pretty carefully. So there was a kind of a sense in which it was sort of an odd exercise. But on the other hand, I knew that kind of from a research perspective, it wasn't clear really on what other grounds you could do comparative work. Because at the end of the day, the policy problem in Japan is an access to justice problem. It's a problem about trying to figure out how you have these medical or legal issues, or what I'll call in a moment justicizable problems in healthcare, and you want to figure out some kind of system that responds to it. And in the Japanese context, whatever the government wanted to embrace, they wanted to move away from this criminalization solution. Anyhow, and it certainly wasn't resolved there. And even Professor Wada did come and spend some time with me in Toronto. And similarly, there was just a sense in which he was not really digging at the problem. But it suggests to me that there was kind of a research challenge there. And then shift to the last year or two. Another hat I wear is as executive director for the Canadian Forum on Civil Justice, which is an NGO that presents itself as the leading think tank on access to justice, or national access to justice issues and civil law reform. And for the last while, we've been working very closely with the Chief Justice of Canada's National Action Committee on access to justice in civil and family matters. And the idea of the Action Committee is really that the Chief Justice wants to reframe how access to justice is understood in Canada. It's sort of presented often as now in the last, as her legacy commitment, and it's the Action Committee is chaired by Justice Tom Cromwell on the Supreme Court. They both take it very seriously. And the Action Committee, though, as a matter of fact, is really made up of stakeholders from within the justice system. So it's, got judges from across the country. It's got Ministry of Attorney General people. It's got CBA people. It's got sort of a mix of stakeholders, almost all of whom are lawyers, I think, except for maybe one or two people. Literally the first working reports have just been put out for consultation. Forums handling the consultation a couple weeks ago. But the truth is that the Action Committee has been struggling with this problem. And the problem is that they want a radical or a reframing of access to justice issues. But in Canada, among stakeholders, access to justice always gets reframed as either access to court services or access to lawyers. And that's actually a bit frustrating, and it's difficult to sort of move those stakeholders off the framework. But what we in the working with the Action Committee are really trying to do now is to pull on a particular socio-legal tradition. It's quite new. It was really developed in the UK, headed by a woman named Hazel Genn, and she now has a group of people. And then their work came out of the Lord Wolfe's work on the justice system in the UK. And the drift of it is to say, let's rethink access to justice. Instead of thinking about it in terms of suppliers, why don't we think more seriously about it as being problem-centered? Right? And again, for people who work in healthcare, in a way, there's a parallel issue. You know, whether you think about healthcare reform around institutions or whether you try to think about its healthcare problems. In healthcare, of course, it's not been particularly successful at getting away from institutions either. But there is a comparable literature. But in the justice context, access to justice context, the work, particularly in the UK, has been dramatic. It's literally changed the landscape in the way in which people talk about access to justice in the UK. Part of it has to do with particular conditions. For example, in Canada and the United States, lawyers have a monopoly on legal advice. That's not true in the UK. So that means that they have a long history of things like citizen advice bureaus that give legal advice in ways that would be illegal here. And so there are certain contexts in which they had certain conditions. But what came out of part of what's come out of my work with the National Action Committee is to really think that there's something interesting about how this work on justicizable problems reframe domestically work on access to justice, but more instructively, it actually might be a way in which we can do the kind of comparative research and agenda setting that frustrated me in Tokyo. And so that's sort of the broad context, and hopefully I'll give you a sense of where I'm going from that. How you define access to justice in general is quite broad. I mean, I've just given you a broad definition up there that I think is, a lot of people would subscribe to. This idea of providing people with information and assistance to recognize the legal aspects of everyday issues and knowing where to seek help, and in effect, whether it's through the formal justice system or elsewhere. So, I mean, that's a pretty familiar idea of access to justice. And in healthcare, when people think about access to justice issues, there's a whole series of kinds of issues that might arise, right? But this is sort of, I think, a quick index of at least 4 of the ones that can get a reasonable amount of attention, right? So issues of professional standard of care, faulty products, public health failures, denial of access to care. Doesn't exhaust them. It's just a set of them. And there are other issues that can be, you can cut it in all sorts of different ways. But just to give you a kind of a sense of the kind of issues. As I said, I'm thinking in the context of a study that compares Canada, Japan, China, and India. And as I said, implicit in thinking about any kind of study of this nature is, in fact, the suppliers are very difficult to make be your comparable. And again, it would almost be uninteresting to kind of point out that Japan has far fewer lawyers than Canada, or that the cost of lawyers is more expensive than in Japan than in Canada, and the cost of lawyers in the United States is cheaper than Canada, the cost of lawyers in China. Those kind of things, in a way, are more about the legal profession than they are about access to justice. But as well, increasingly, the way I've been thinking about good comparative studies in Asia Pacific is actually having a rich database. To actually have something interesting to actually compare, and have a database that's rich enough to actually offer genuine insight into how problems are resolved in a comparative context. Those are sort of the broad requirements that I see as coming out of this. Now, let me just, as a side, give you a sense about some of the limitations of other approaches. So probably a lot of you know and were sensitive to the issue about medical error. It got a lot of attention about a decade ago. There were a number of big studies. This is just data, one of the review studies from about 5 years ago that just, highlighted the high incidence of medical error, the death connected to medical error range, depending actually on how wide you count medical error. But this kind of phenomena is quite familiar. Probably most of you also know that medical error as a field, it was kind of a cutting edge, interesting potential, and it's largely kind of fallen off the radar. I don't mean completely, but there's far, far, far less talk about it. And to a certain extent, it's been a bit of a blank wall, certainly from a point of view of access to justice. Where it has had some impact, right, is on, for example, hospital practices and so on and so forth, right? There's been, I don't mean to say that it hasn't affected healthcare practices, but from the point of view of trying to think about access to justice, it really hasn't proved to be very useful. And I'll just kind of give you a quick reasoning. When people run through medical malpractice and law, there's typically the two paths and so on and so forth. But what quickly becomes evident to almost anyone is the lack of fit between medical error and medical malpractice. Whatever medical malpractice doesn't give you really much insight about medical error. There's really, however medical error is handled, malpractice is not the way in which it's predominantly handled. Okay, which is... okay, well, I don't even want to go down that road. That's why I gave you that simple chart. Okay. But for sure, that's a problem. And if, again, for people who don't know, in Canada we have a relatively distinctive medical malpractice phenomena where basically virtually all physicians and surgeons are insured through a single insurer, the Canadian Medical Protective Association. It's not an insurance company, it's a cooperative. It sets fees. The premiums are, by American standards, relatively modest. They are often part of the agreement, collective agreements between the provincial medical associations and the provinces. Significantly, and this is part of what distinguishes the CMPA from insurance companies, it rigorously defends all claims, no matter the cost, so it doesn't have any nuisance settlements. And typically, it doesn't settle until they've done discovery, right? So, and that's actually not a trivial factor, right? Because the cost of discovery is often very significant. And to find it, for a plaintiff to find a lawyer often is actually in itself a challenge unless the individual is willing to carry risk paying out the discovery costs. So I mean, so when I say it doesn't have nuisance settlement and they go to discovery, it sets a certain category. Now what tends to be pretty striking to most people is the small number of medical malpractice suits that are settled, right? So basically, these are numbers from almost a decade ago. They're largely still the same, right? Basically, 1,200 suits. You go back and compare that to the medical error rates, and that's why I say medical error, or medical malpractice, whatever it does, doesn't provide a whole lot of insight about medical error. And then you take those numbers, right? 1,200 suits are settled or are filed, and then 67% are abandoned. My suspicion is largely in the context of people facing costs of discovery. right? So again, it means that you're down to 300 or 400 suits. And roughly, after discovery, the cooperative makes a decision to settle about 3/4 of them, presumably because in the course of discovery they get pretty good evidence that they're going to lose. And then 6% go to trial. And again, within those 6%, they win 4 out of 5 times. Right? So it's really, the point is not to go back to my original point about my hesitation about the Japanese context was, say, if you're trying to think about what's going on in society and addressing justicizable healthcare problems, malpractice is probably not the place to look. And again, for good law and society scholars, that's not a surprising finding, right? But in a sense, it almost has to be reiterated because it sort of seems to be people looking under the light because malpractice is something that you can quite easily research.
Now try to figure out the point, okay? Because an error can be just a result of the stochasticity of the case, or
Alon, in a way, I want to shift you beyond medical error.
What?
Because I'm raising medical error to kind of say that was one route that people thought about taking. Okay. Right? I mean, you can think about it in different ways, okay? People began to become sensitive to the idea that healthcare justicizable problems are potentially huge. And that's what that medical error stuff did. The medical error stuff was kind of front page of kind of Newsweek, Time magazine stuff a decade ago, and people were saying, wow. Right? I mean, it kind of got at this idea that there's a huge potential, if you want, legal problems here and liabilities and all those kind of things. But I'm just saying, actually, in a way, it's a red herring. Okay, that's my both medical error and medical malpractice, and for the reasons that I'll explain to you. I'm not trivializing them. I'm just saying that. Okay, so let's go back and try to think as social science researchers, how else can we think about this problem? And how else specifically can we think about it in a comparative context? Okay, so, and those are the kind of two things that I'm trying to frame, okay?
My last question.
Okay.
You're talking about, I'm trying, maybe I lost the thing. I thought you started talking about excess.
I haven't given you the positive agenda. I'm just trying to get you to get a sense about the landscape, okay? And why that way of thinking is misleading. In the same way that, to put it crudely, okay, to go back to the National Action Committee. Lots of people on the National Action Committee would look at my malpractice stuff and say, that just shows that it's too expensive to pursue a malpractice case. How can we get the discovery cost down? How can we make it cheaper for people to pursue these cases? Okay, right? You understand? That would seem to be a pretty sensible way to frame the problem.
No, I think that
the
malpractice, the message of the malpractice is that you have lousy doctors or crooks. So it is nothing to do with excess.
No. I think to be fair in malpractice.
What?
Malpractice, I mean, a significant amount of malpractice is mistakes with harmful consequences where it fell below a reasonable standard of care. Without it being...
Without intruding, maybe we'll just let him go through his...
Anyhow, but do you understand? Do you understand what I'm trying to get? I'm trying to get at that there's a different way to frame these access to justice issues, and it actually lays out an interesting comparative agenda about thinking about comparing, if you want, the four countries. In a way that actually I think just at many levels it doesn't work around malpractice. Again, it's not a surprise. Japan basically did not pull out any reforms from looking at the comparative example. Because at the end of the day, it doesn't really get at the nature of the problem. Okay, so what I trying to get at is that when you're thinking about healthcare and when things go wrong, those are civil justice issues for the most part, right? They're not criminal justice issues. And criminal justice issues are overwhelmingly system-centered. Whereas, so the and you know in the language I use here, going to court is not the gold standard in resolving a lot of civil justice problems. People understand that in a family justice context. They understand in employment context. They understand it in all sorts of contexts in civil justice. Whereas in a way, criminal justice, it's not absurd to see the gold standard being the criminal justice system. Right? But in civil justice, that's doubtful that that's the norm, or well, not only is it the norm, it's not even the aspirational standard. Okay? And what the legal or justicizable problems approach tries to do is tries to think, what can we learn about the problems people have and how they resolve them, how they can resolve them better, how you can facilitate that resolution, maybe in part in the court system, but not exclusively in the court system, and often not preferably in the court system. And again, for thinking about doing comparative work involving both China and India, that's probably a good thing. Okay? Which doesn't mean that these things don't operate in the shadow of the law and all these kind of things. It just means that if you're going to think about these problems and trying to do a comparative study, you're probably better off trying to think about it in a different framing. And another feature, though, or issue about healthcare and justicizable problems is lots of people don't see their problems as legal problems and don't see them as having a legal dimension until they're often well advanced. And so what you began to get basically in the beginning with a seminal study by Hazel Gann in the UK, was trying to think about sort of justice, what she called justicizable events, but actually I prefer problems, where it wasn't an issue whether the action was taken to the civil justice system, but rather whether it had some kind of dimension that it was imaginable that it was a civil justice issue. And again, you come back to medical error, and part of the complexity about medical error is trying to think how many medical errors have that dimension. Right? That's actually something that's almost never answered actually it's not answered, certainly in the Canadian work on medical error. And moreover, when you're focusing on problems or events, what most people realize in the civil context is that legal problems are closely tied to a whole series of other problems. So that family problems might have legal dimensions, but they have a whole series of other dimensions too, right? Anybody who represents a family breakdown as simply a legal problem is being far too simplistic about their understanding of the problem. And likewise, often healthcare problems are actually part of a broader set of other problems and so on. And so when you set it up in that way, of course, part of the broader agenda, say, in family law that we've seen is this idea that we actually need multidisciplinary practices to address the problems, where people are thinking, well, you know what, you want a family service model that has not only lawyers involved, but has physicians and debt counselors and a whole range of other service providers, right? And that has the effect of making the formal justice system seem perhaps a little bit less central. Okay, so and that's just a broader context. That's not specifically about healthcare. Here, though, we've actually now are beginning to have this set of studies that are comparative. We're beginning to get some rich data. The Justice Department has commissioned 3 large studies, 2004, 2006, and 2008. The English study, definitive study in the late 1990s. They did a study in Scotland, 2004. The U.S. study, a New Zealand study, Netherlands study, a Japanese study, and actually the remnants of a Hong Kong study that I'll talk about in a couple of minutes. And some of these interesting features is that generally what these studies show is how many justicizable problems people have. And the incidence is quite high. And again, for people who often, for example, project the Japanese as not having legal problems, the data is quite strong to say their incidents are lower than Canada, but they're not non-existent. They're a significant number. Basically, 1 out of 3 have some kind of justicizable problem over a 5-year period. Okay? And so, which means that you ask, how do people resolve these problems? And what you do know is that these justicizable problems are very unlikely to all be resolved in the formal justice system. Now, let me just pull out some Canadian data to just kind of begin to think about some of the richness of the issues. Not surprisingly, the biggest issues for Canadians, the justicizable problem, basically 1 out of 2 Canadians are going to have a justicizable problem over a 3-year period. Which again, if you kind of do huge, that means that works out to something like 10 million justicizable problems in the country over a 3-year period. Sizable number, far, far, far more than our justice system actually handles. But among those, 30% of them are consumer problems. 20% are debt, 17% are employment, only 4% of them are family breakdown issues. And 2% are health. But 2% are sizable numbers, right? It means that health problems, justicizable problems, are that family problems are only twice that. Even though when people think about access to justice in the civil justice context, family is always the running example that people use. Even the running example I'm using here, right? But interestingly enough, health problems are actual significant numbers. But on the other hand, again, not surprisingly, about 40% of justifiable family breakdown problems actually end up in court at some level. Whereas family ones, it's only 8%. Again, not a big surprise if you kind of think about that. And moreover, in the health, and about half of those ones that end up in court, people actually have a lawyer. So you're beginning to kind of get a bit of a picture, and then you wonder about, well, what happens to the other 92% that don't end up in the courts? And you find that about a half people just try to resolve on their own. And then about a quarter people get some assistance, but it's non-legal assistance. And interestingly enough, that 18% people just lump it. And so you begin to kind of get a vision of how people deal with problems and how they're resolved. And you can begin to ask, should we be doing more to support people in resolving these problems? But it gives you a much better mapping than you were going to get from malpractice. You're going to get, in a sense, a much better picture. And on the other hand, you're going to find some disturbing phenomena. So, for example, even though health justifiable problems only account for 2% of total problems, 84% of those problems were significantly disruptive, and 55% were extremely disruptive. So in other words, actually health problems that are justifiable are significant problems to people in their everyday lives. And interestingly enough, 96% of people said these problems were important to resolve. So in other words, in both instances, health problems were both the most disruptive of all the problems that people have, and they're the ones that people most want to resolve. Whereas, for example, if you say, look at consumer disputes, you actually find that people often don't find those especially disruptive. Right there, I bought a TV or I bought a computer and it didn't work properly and the manufacturer didn't honor the warranty or whatever it might be, right? It might piss people off, but it doesn't cause major disruptions. And frankly, resolving it doesn't become a high priority. But health problems actually top out on both of those measures, which is, in other words, people take them very seriously and they really want to resolve them. Which in the language of urgency, you would characterize as being particularly urgent. There is data, but I actually just haven't mined it, and this is what I say about this being, in a sense, preliminary. There is data about how many of these problems were really resolved and so on. By asking these kind of survey kind of questions, we're able to actually, it's there, it hasn't been fully taken out of the data. Now, my point is you begin to get an interesting map that allows us to do some comparisons. And so you shift to Japan, and Japan actually has a less detailed, and I actually only have a summary, very brief summary of the findings in English. And that's, but there is some interesting, for example, this 34% over 5 years. In other words, justifiable problems are a major problem. And the indicators are that health, likewise, is a significant problem, grouping within those problems. When you begin to kind of try to think about the access to justice kind of questions, then you can also dovetail it with some of the qualitative work. So, the issues about trying to think through how rights claims are resolved. So, for example, Feldman has this general claim that which dovetails, his work was done before these justifiable problem work was even begun. But his central claim is that it's not that Japanese don't have justifiable problems in healthcare, and it's not that they don't see them as rights problems, but rather that they actually use what I call, he doesn't call it, but a delayed rights claim and dispute thesis. So generally he says, what happens is people actually don't press them at the beginning, because if you press rights at the beginning in a Japanese context, it's going to take much longer to resolve. So he gives, a simple example of, having a car accident in Tokyo versus having a car accident in Philadelphia. Kind of says, you have a car accident in Philadelphia, immediately somebody wants to see your insurance and take your insurance thing, and then he kind of says, in Japan, everybody has insurance. They recognize that it can go to insurance if they want to, but people will kind of almost immediately on the side of the road kind of say, how much do you think that's worth? They'll start just kind of negotiating, not as a matter of right, but just because they just see that as the way in which they'll resolve the problem. But again, his point is to say it's not because the rights don't matter, but rather that there's a strategy that's involved. And that actually, it plays out in certain issues. In general, when problems are moved beyond those preliminary stages, they do become rights claims. So, and again, for people who know much about Japan, it's always been odd when people insist that rights don't play a role in disputes, even though we've known that things like environmental disputes in Japan, which become heavily escalated very quickly, actually quickly involve people invoking rights. And so this idea, plays out in a number of different types of justice problems. But in a sense, I'm just trying to get at that you could actually do some interesting, by mining this data, you could actually, around justifiable problems, you could actually get a better picture of the access to justice issues in healthcare in a Japanese context. And I mean, and in China, it's a similar kind of phenomena where, like the work of there has been some work, not a huge study, but apparently Carol. Do you know her? Carol, she's now back in Wales. Carol. No. UK. Geez, I've forgotten her last name. You would know her. Yeah, she was at Hong Kong. You know who I'm talking about. She actually apparently has done a study, but she's actually been sidetracked for personal reasons, and it hasn't been released, or the data hasn't been, I'm not even sure whether it's been put together in any form yet. But there are some numbers here. Again, you would have to dig down and see how much of it is actually about healthcare. Obviously, in Hong Kong is not comparable to the rest of China, but there are some interesting examples that right now there is this increasing use of tort injury claims in China around healthcare claims, but on the other hand, the role of protests. So the Mickelson study on rural healthcare unrest is nice illustration of that, or one of our colleagues in the Asia Pacific Dispute Resolution has just done unpublished, really quite interesting work about which I'm sort of just putting together the picture about the emergence of these hospital protests. And the idea, the phenomena is that people will feel that in some sense they've been injured at a hospital, and the first move will be actually to begin to gather friends and relatives outside the hospital and begin to protest and to try their best to shut down the hospital. And it becomes a negotiating strategy, and hospitals will often settle because of this. But from the way Sarah describes it, there are now tens of thousands of these protests in China. And it's an example of responding to justicizable health problems, and some of it is the costs of pursuing tort injury claim. Some of it is that this is probably a quicker way to reach resolution. There's a whole series of kind of considerations that are at stake. But again, by kind of mapping on the justicizable problems work with the ways in which you resolve, you get a much better picture than, again, focusing narrowly on the court cases. And then similarly in India, where there does not exist any, I can find any justicizable problems research that's been done there. But again, the mapping of the picture is complex, where we realize that in India, the distinctive role compared to the other three jurisdictions of NGOs and the role of the Supreme Court in public interest litigation are huge ways and arenas for people actually resolving disputes. And trying to figure out some way to fit that in to make it comparative to the other context, and trying to figure out whether this is genuine access to justice. So people find the public interest litigation an interesting path to justice in India. And so some of you probably know this. This new public interest litigation that's gone before the Supreme Court. Now it hasn't been settled, right? Along you would know about the Novartis case. It hasn't been right. The argument's just started, right? They haven't issued a decision. Right?
Yeah.
But trying to understand whether that's genuine access to justice is a hard problem, right? Because on the surface, it looks like access to justice. At another level, concerns about the corruption of the Supreme Court, all these kind of things. By seeing how it meshes onto the justicizable problem findings, we would actually have a better picture of what's going on. So that's, like I say, it really is it's a work in progress. And for it may not strike you this way, but for me, it's actually a way to do research that I've been thinking about for a number of years. That now I think actually I can see how we can do it, and how if we can just mesh on these databases. And significantly, none of these databases have really been compared. Even though, in fact, they've been largely working from the same script in the sense that they're all inspired by Hazel Gen. It's initial work, and basically have taken her initial questionnaire work and actually adapted it to their own particular countries. But there's quite surprising similarity there, and think about it. And Pittman knows we did do some survey work in the first stage of the 8R, where we actually were asking some questions that were actually getting at this just not in a conclusively systematic. But our instinct was that there was something there. And full circle, it actually reinforces the idea that there's something there. And I also haven't gone back to look at the results through this lens because I wasn't really think that access to justice as being the driving question. But
well, we can what would you do in the event of this kind of experience?
Right.
What channel would you use? So there, and perceptions on what channels are available also can be related to perceptions about this broader theme of access to justice, depending on how you define that theme. So
but if you recall, we also did have questions that asked, "Have you had a dispute?" Right? We actually didn't just ask the perception. Michael, were you?
Yeah, I'd like to know a little bit more about how you drill down for the original data. So that would be interesting. The other thing I was wondering is council's resolution. In some cases, I can think of 4 R's here. I can think of somebody wanting a remedy for something, somebody wanting a restoration of something, somebody wanting to get even, revenge. Some might just want recognition that something bad happened to me, and I would like you as the caregiver to acknowledge something bad happened. I don't figure you can do anything much about it, but at least I'd like an apology. I'm thinking about cases like the misdiagnoses in Protestant Lutheran and stuff, or of breast cancer and stuff, with systematic things. I think some people just want it to be recognized. Others desperately needed help of some kind.
Well, there's actually, I mean, there are a lot of those answers in the data if you can, but it requires actually literally sorting through this. Most of the questionnaires typically have about 80 different strands of questions because they obviously are. It identifies. In the Canadian context, it identified 30 different types of problems. So, including health problems, but, a wide range of kinds of problems. You do have to dig through some of some of the more interesting work that was done in the Canadian stuff that was not in the original Jesus Again stuff. Was about how resolution affects perceptions of fairness. And interestingly enough, one of the more significant problems issues is that there are all sorts of correlations between people having multiple problems. So the truth is that people who have one legal problem, and if you want a civil justice legal problem, will often have many. There's this so-called cascading effect. So I can't tell you the numbers off the top of my head, but my guess is between 40 and 50% of people who have a health justicizable problem have 2 other legal problems, say employment or actually, and there's actually a certain clustering. Again, not surprising. People who have debt problems who often have employment problems and consumer problems, and so there'll be kind of clustering as well. And the more problems people have, the less likely they're actually to perceive the justice system as being fair. Which is different. Which is a different insight on something we've known for a long time. We've known for a long time that the more people interact with the justice system, the more they think it's unfair. But most of that empirical work pointed out that it didn't matter whether for example, you were a plaintiff in a case, a defendant in a case, a witness in a case, whatever your role was. If you were involved in a court case, you actually tended to basically be much less optimistic about the fairness of the justice system. Whereas this actually gives it a different take. It kind of says, chances are the justice system, formal justice system, does not do a good job of handling people with multiple problems. And so again, in a Canadian context, there is stuff on race, Aboriginal status, and there again is quite interesting correlations between those identity markers and people who have multiple problems. And so you can dovetail with some of the other data that human rights commissions have had for a long time about, say, for example, why that Aboriginal people are much more skeptical about the justice system. And the typical take used to always be kind of something like it's white justice or something like that. This study is actually saying it probably is more complex than that. Anyway, I don't know that, but I think for sure figuring out how you categorize resolution and what constitutes resolution. I'm doing another study in a way that's only tangentially connected to this stuff at all for Community Legal Education Ontario about the role of legal information versus legal advice. And we're literally just trying to design it. I'm working with a woman named Melina Buckley here in Vancouver. And the problem with that, most of the work on that is that it's purely satisfaction measures, right? So whether people were satisfied with whatever. And most accounts, I mean, my instinct is think that's not really a good measure. If you want to get at the quality of it, seeing whether people are happy isn't a very good measure. Likewise, the issue about resolution, about how people understand resolution, is which partly goes to your kind of triad.
If you want to compare studies, you would then have to do more fine-grained analysis so you can use the same markers in each of your survey instruments.
Right. But I mean, to a certain extent, it's promising because some of the Canadian and Japanese work has already been done for sure, and so it's not exactly as if you're starting from scratch.
I'm still perplexed. What is the question?
Okay.
No. What is it? I mean, I'm waiting for the positive side, okay? So since time is running, I will get the positive side. But what is the question? And how, first of all, how the data that you presented can actually answer the question. And the second thing, why not do a proper one country study with appropriate controls, etc., that answer the question rather than looking at data that by your own admission, comparative data that suggests that problems are different in different countries, cultures are different, institutions are different, standards are different, training, the ability of medical peoples are different, which then, I mean, the law is different, so kind of like...
Let me run it this way for you. I mean, it's a valid question, right? The thought is that how can we map access to justice in a way that actually provides genuine insight? Okay, I mean but it is in the contrast to the way in which people have thought. Right. So if you put the interesting enough, access to justice as a term, even though people batted it around, they're sort of people would say no access and so on. Access to justice as a term apparently largely emerged in the late 1970s. Do you know the answer to this, Pittman? But I've heard claim that the first time it was used in print is actually in 1979 collection by Brian Garth.
I think it's basically access to justice is a outgrowth of a combination of American legal realism and law and society studies. So law and society studies are looking at what are the social impacts of law, and American legal realism is looking at how law actually operates. So you take those two tracks, and it surprised me by the late 70s, they were saying, well, let's think about how people are really able to, i.e. members of society, are able to actually use those legal institutions to change things.
Right, but the point is that the way in which people map that was that, like for example, I did the report for the Canada report for there's an institute in New York that was doing the basically a mapping of access to justice across the basically across the world, and Pro Bono Alberta was in charge of putting together the Canadian report, and they actually asked me to do it, and it was just, and basically they had a template, right? Boom, 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 and every country filled in these kind of right, and in a sense, it was fine. And maybe for a first-year law undergraduate, it kind of might give them a quick kind of, oh, well, look, but in a sense, the amount of insight was incredibly limited. And likewise, like I say, to count lawyers or to count legal aid budgets or whatever, it's not an especially insightful mapping. But the question then is about the mapping. Okay, now you're absolutely right that you could do a mapping just in a particular one jurisdiction. Okay, and to a certain extent, that wouldn't be a trivial achievement. Okay, but in a way, I think two things. One is that I actually think the comparative work shines a lot of light on one jurisdiction, right? And then, secondly, part of the point about this is not a project about comparing access to justice across these four countries. It's actually pulling out what in a Canadian context is 2% of the justicizable problems, and let's just pull out that slice and try to think about it comparatively. Right? In a sense, it's a more restricted account. My guess is that if I wanted to, in a Canadian context, I could actually do a mapping.
Can you just technically, this is a technical, maybe if I was a lawyer I would understand it better, but technically, tell me, how do you decide that something is justiciable problem?
Well, again, this is part of why this work is interesting. Okay, it does it in two ways, right? One is that it's obviously survey work. Okay, so in a sense, it's no. So in a sense, it's self-reporting, right? So in other words, people are asked whether they understand it to have a legal dimension. Okay? So, so in a sense, that's self-reporting. Okay? I have this other work on legal consciousness that kind of says, that's an interesting aspect. But it's also this genuine intuition that when it comes to civil and family justice issues, in effect, a lot of them do have legal dimensions, right? So debt problems on first blush, people may not think about this having a legal dimension, but obviously with a bit of questioning, people can see that there's a legal dimension to it. And other issues like immigration, most people immediately get that there's a legal dimension to it, right? Family, arguably one of the transformations that's happened in the last 30 or 40 years is seeing certain family problems as having a legal dimension in a way that they weren't before. I mean, arguably that's one interpretation of sensitivity around things like domestic violence or treatment of children, or, right? You know, so there's a sense in which it is an evolving phenomenon. But the comparative data is quite striking, that there's surprising amount of convergence across countries in terms of people seeing similar problems having a legal dimension. So, for example, we had in the APDR survey, human rights survey, this the question about a warranty question, question about an expired warranty, and lots of I think that the vast majority of people who responded to that question didn't have a difficulty seeing that it was a legal problem, whether they were in Japan, China, or Canada. But the justice-sizable research is basically just much more systematic.
Can I just
Yeah.
ask, to time this, I want to make sure that there are graduate students in the room, that graduate students have questions. I think we should make sure that the professors don't take their arguments and dominate the time, so which happens sometimes at universities. Never at this point.
Yeah.
So if there are graduate students who have questions, I would encourage them to step up and ask. Otherwise, I have a question. Well, okay, so the thought that occurs to me actually is that what you're really doing is you're using the medical resolution of medical disputes as a way of kind of interrogating the utility of access to justice paradigms. Because when we think about access to justice, we have two dynamics. We have what is access and what is justice. And when we use that justiciability question, we are kind of we have to be careful, because on one hand, if we ask people, is this a legal problem? They may say it is or it isn't. But if we ask a court, is it justiciable? They may have a different set of answers. A court may say it's not a justiciable problem, even though it's a legal problem, right? So I'm not thinking in this context, but I'm thinking in the context of, say, New York Convention on Arbitral Awards, right? So it's more about the medical. So when you have a court that is receiving a claim under that convention, one of the questions is the matter something which is amenable to the jurisdiction of the court? Is it justiciable? And the court, in many cases will say yes or no. One perfect example of that is the issue of whether you can have an arbitration clause in a securities contract, which basically says if the party issuing securities violates some standard or another, do you take them to arbitration? And one of the questions is it's a policy issue, but that courts are not, that is an issue of public policy. It's an issue of violation of public law. It's not a matter that can be taken into arbitration. So it raises all kinds of, from the institution's perspective, justiciability issues. That is a completely different dynamic than what a party thinks is a legal issue. So that's one of those. Then the other thing that occurs to me is what is access? And I think this was really interesting. Is access, does it mean your ability to hire a lawyer? Typically, in access to justice issues, it is intersected with socioeconomic status questions and the issue of who can afford lawyers to fight the battles. But on the other hand, what we might actually think about is what does access mean? Does access mean being heard? So I think the point I was making about the Newfoundland is really a wonderful one, because we see that in China too, where the real desire is not actually to get a remedy. The real desire is just to have somebody hear that you have been wrong. That's like really important, right? So, and then that allows us to look at the socio-cultural dynamics of the people involved. So I would say that even though we're doing it comparatively, or you're doing it comparatively across countries, it would be very interesting to do it comparatively across socioeconomic groups and socio-cultural groups within a particular country. And I would hypothesize that there are certainly, this gets into the whole selective application issue, but there are normative dynamics that inform the way members of communities view the question of access. Is it, I have money to hire a lawyer and get my lawsuit filed and get a judgment? Or is it, I have relations that allow me to interact with the provider or the hospital in which that has a conversation and admits me into that conversation? I don't know what access means. And then the whole thing about justice. Is justice fairness? And that would depend really on who you ask. If you ask lawyers, and this has been done, this is Carol Greenhouse. Yeah. The Carol you're thinking about is Carol Peterson.
Yeah. No, actually, not Carol Peterson. It's Carol. Carol Peterson's now in Hawaii. It's Carol.
Okay, then I know now we're getting close.
Yeah.
So the issue of what is justice? If you take a random sample of 100 lawyers and ask them, is justice fairness? I would be very surprised if more than 1% of them say yes. Lawyers do not even operate in that world. Lawyers are not interested in whether justice is fairness. They're interested in whether justice is the rules being followed. And it took basically Rawls to actually get people thinking about the notion that justice is fairness. But frankly, most practicing lawyers, that does not resonate with them at all. So I would say that you will have a socioeconomic, sociocultural, normative set of variables that inform the way in which people think about what justice is. And that also informs it. So you can do that even within an economy and look at different sociocultural groups. So that's not really a question, more than an observation.
I'll make two comments. Actually, a lot of that I just struggled with that was this paper on fairness in business. Literally last week. But the comment about the access, right? The original, I did a lot of work on equal opportunity. And in all sorts of contexts. And the one area where I shifted from equal opportunity to access was talking about healthcare. And so I wrote a lot about access to healthcare. And increasingly, since that equal opportunity, the original equal opportunities book, I've been increasingly kind of saying, in a lot of contexts, opportunity, or the currency of opportunities, is access. That's actually the phrase that I'm using. So when I kind of say education, there the issue is opportunities are about access, but specifically when you think about access is not a simple rubric, right? You begin to ask access for whom, access to what, access at what cost, access where, all those, questions, but, and those, in a sense, those are similar questions that if you break down access to justice, you want to kind of through. So in India, I mean, that's why I say about the public interest litigation movement in the Supreme Court, I understand why people see that as an access to justice issue. On the other hand, I look at it and kind of think, it is still an extraordinary elite path, right? There's just, in my most optimistic take on it, it still is a group of extraordinarily elite Indian lawyers and judges making judgments about the well-being of admittedly disadvantaged.
An issue, Carl Minzner has a recent article called Retreat from Law in China, and part of the issue is the debate between the Chinese legal community and the more civil society community over what are the most effective mechanisms for granting redress against government So China has a whole legal regime about judicial review and judicial litigation, all that kind of thing. And so the legal community say, hey, we got all this stuff. Hire a lawyer and use the courts, But the civil society people say, but people don't have the literacy, they don't have the resources, they need that letters and visits system, which is much more informal. So that whole debate is very much
right.
And it seems to me that what you really, or one thing that is coming out of what you're doing is to just force an interrogation of the whole access to justice discourse so that we realize that it is specific to particular socioeconomic perspectives, particular institutional capacity, linkages, and so on, and that maybe we need to think about it in a cross-cultural context, because if we think of access to justice in a cross-cultural context, we're going to find out that the meaning of access changes with local knowledge, and the meaning of justice changes with local knowledge, and therefore the whole thing varies, and that would be a great contribution, I think. Right. And then you could use medical malpractice as one case study, you could use land use rights as another one, you could use landlord-tenant as a third. I mean, there are lots of those areas. They're classic examples of access to justice in a North American context, but if we take them internationally, you may find lots of different things about it. So that would be quite interesting.
But when you have, since I'm writing this was maybe they should warn that there are some logical issues
I don't deny them.
And I'm not talking about just clear research questions. Now, seriously, when you were talking, actually Pittman raised them indirectly, some of my concern. You see numbers, right, which are international. So in Japan, and they are similar in some ways, and you say convergence, but it may vary. First of all, there is what is justiciable, and this may have to do with the legal culture of how aggressive and greedy are the lawyers in the place, right? Because one way to create demand for lawyers is to educate the population that they could, So you have a lot of different cultural and social kind of things that just to do with the justiciable. On the other hand, you have how many actually of those get into the courts. And then here Pittman said, well, the courts may have, there are different laws, okay? So some things don't get to courts because the laws are clear. You yourself suggested there are mechanisms like in Japan, a lot of things will be resolved probably. So just looking at the numbers, I would say it's very good because it engages the audience. Not the audience, but it's a nice thing to start the inquiry. But the inquiry, I think, should start by being more or less qualitative rather than quantitative.
But
to control for a whole lot of things.
Right. But two comments. One is that I took Pittman's point was that there's actually two working understandings of the term justiciability. One is the term where it's a technical term, meaning can you bring it to court, right? And that's my colleague Lauren Sossin has written a book about justiciability, and Lauren uses it in that narrow sense, even though actually he likes this kind of research. Right? So there's a sense in which, and clearly it's not being used in that technical sense. The idea that it's culturally specific, that runs in a number of different ways. So issues even about what constitutes health is itself a cultural issue, right? So there's a sense in which you can run it. It becomes the kind of questions about doing any kind of cross-cultural survey methodology. But in terms of the tightness of the questioning, the thought, the intuition of the Genn research was a qualitative observation, right? Basically, she's saying, listen, look around the UK. To the best of my knowledge, she actually has only done work in the UK. She's, look around the UK. There are multiple paths to justice, right? The study was called Paths to Justice, right? Multiple paths to justice. Some of those paths are formal dispute resolution. Some of them are alternative dispute resolution. Some of them are people solving problems on their own. You know, there's a wide range of recognizing these multiple paths. But in a sense, to even make sense of that initial intuition or insight, you actually have to kind of say, well, what are people on paths to do, right? Is there something there? And if you flip back to how legal needs surveys, there was a period, right, in the originally when people like Lauren Nader and some of the other sort of early Law and Society people who did stuff on what we would call access to justice, even if they didn't call it, they kind of were, they were thinking, well, gee, what you do is you can do a legal needs audit. Let's figure out how many legal needs people have, and let's see whether they're being met. In the same way that you sit down and say, how many hip replacements do we have? Do we need? Do we have institutional capacity to meet that, right? Boom, boom. And people thought that we're framed it in the same way. And once you really began to get serious critical thinking about that, people were kind of saying, how do you even make sense of that language of legal needs? Isn't that people asking, do you really need lawyers, and so on and so forth, right? And so there began to be a reframing the idea. The justiciable problem is to try to say that it's a bit more like I've just come. It's a bit more nuanced of a kind of study that you want to make sense of. You kind of want to realize that so-called legal needs are actually across a wide continuum, and that there are. I did a study for the Law Commission of Ontario a couple of years ago about family law, and the language that we used in that study was to distinguish between family problems and family challenges. And the thought being that there was kind of this challenges might spiral into problems if they're not resolved, but some things are just challenges, and people kind of deal with them, and but problems might become something that end up in the court system.
That's another example of getting quality first. And in fairness to Lauren Nader, that's really what she's doing. When she used the term legal needs, she's responding to a highly institutionalized, highly formalistic way of doing comparative law. And she really said, look, we have to step back from that and look at something that is more attuned to local realities. So she's looking at local rural conditions in Mexico or wherever she's doing her field work. And that's really the attempt to put an anthropological, local knowledge, qualitative assessment on these categories so that we're not looking at them exclusively through the lens of a North American or European trained former lawyer. And I think actually she says that in the introduction to one of the books.
Right. I think in that Disputing in 10 Societies book.
She's trying to get away from it.
Yeah.
When I say, well, legal needs and then how do
I...
a start.
Oh, I don't mean to trivialize.
Because it is 6:30.
Actually, there was one question.
It was just somewhat of a parenthetical question to this. I'm from the States, and something that you can't kind of get through watching anything on television without running into is some ad for, have you or somebody you know taken X drug? If you have, please contact us. Or have you been in an accident recently? If you have, please call. And I just don't know if the same sort of phenomenon exists in Canada or in other systems, healthcare systems that aren't as the U.S. is, or lack of.
Right. No.
But to what extent? It seems like that at least is so much more like an in-your-face, in the masses, not in a sitcom setting of law that could at least influence, in a sense, the assent to access to justice.
Right. No, actually, it's a spot-on comment, because the first if you want to attempt at a comprehensive study, was this book in 1979 by Brian Gareth, and I can't remember who the co-editor was, but it was called Access to Justice, a Global Study, right? And they kind of, tried to do all this, basically kind of counting lawyers kind of exercise, more nuanced than that, but they actually, the looking back though, they actually say access to justice really is coming in waves. And so they say, the first wave, the post-war wave, was to think about access to justice for individuals, right? Individuals have problems. What kind of legal services can meet those individuals' needs? And then they say the second stage was kind of thinking about access to justice as a kind of group problem. And their point being that things like class action suits are an example of attempt to aggregate, if you want, harms, and achieve justice through that route. And then they kind of say the third stage, when they were writing in 1979, was the emergence of alternative dispute resolution, kind of an informal kind of justice mechanism. But it does for sure fit into that realm. A problem, and not a trivial problem, with the justicizable problems surveys that is that it's all about surveying individuals, right? And that's not a trivial problem, except that in defense of the methodology, it would say, well, the problems are still problems of individuals. Class action is just a way of aggregating individuals to, it's a vehicle for justice. It doesn't deny that it's all about aggregating individuals.
That's a perfect question that you asked, because the individual's response may depend on whether they see themselves as an autonomous actor or they see themselves as part of a community.
Right.
In which case, they may be speaking, they may be hesitant to speak, or they may qualify their responses if they perceive themselves to be a member of a community, because and we see this with Tibetans all the time, which is the question of, when we speak, are we going to be properly representative of the community that we are at least perceived to be attached to? So, that's classic.
In the Canadian survey, discrimination problems are as numerous as family problems, around 4%. But interestingly, there, about 80% of people say that they just lump it. But presumably discrimination problems are something that for sure people will typically identify. I think it's actually racial discrimination. I think it separates out disability. And so there's a sense in which clearly that's an example of also group identity with a problem. They're hard problems, right? Okay.
Well, so it's been a wonderful session, and I just want to remind people that our next session, which is supposed to be telling me in here where it is and when it is. So let me just here we are. The next session is on Monday, November 19th, and we will have Mayor Eyal from the Global Health and Social Medicine program at Harvard Medical School, speaking about medical tourism in South Asia. And so I encourage folks to come to that. But in the